My name is Peter Ventura. I'm an attorney in Worcester, Massachusetts. I'm a personal injury attorney at this point in time. It's sort of a specialty or a focused practice. Originally, I was an assistant district attorney going back to 1982 to 1985. After a few years as a prosecutor in Worcester, I opened up my own practice, focusing mostly on civil work. But after maybe 5 or 6 years, I kind of focused and specialized in personal injury, which I've been really almost exclusively doing for the last 20 years or so. The fact pattern involved a woman who was around 50 years old, close to 50, and she was an employee of a supermarket. And she was a cashier and did some administrative work. And there was a particular point in time where the supermarket was closed, and there were cleaning personnel inside the supermarket. And she was arriving at work, going into the store before the store would open to, get her cash register and get her work ready for store opening. Well, what happened in this particular case was her employer, the supermarket, had hired a cleaning company to clean the floors, wax the floors, etc. And they had hired a subcontractor to do that work. Well, in any event, my client had come into the store one particular day, and as she was walking from one part of the store to the other, there was a cleaning person that had said something to the effect, "Oh, we're cleaning the floors. This area is a little wet, but walk this way." Kind of pointed a path where the cleaning person wanted the plaintiff to walk. And she did just that. She followed his instructions, but she fell. And it was revealed that on her clothing was a variety of wax or floor stripper. So this was a so-called third-party case. She was injured at work, received workers' compensation benefits, but a legal claim was made against the cleaning companies who were responsible for this work. It was an interesting case in the sense that it involved liability issues of a person falling down. And as young lawyers will learn when they start doing these types of cases, in almost any fall-down case, there's going to be a defendant or an insurer that's going to blame the person who fell, arguing, well, it fell because you weren't looking where you were going, you weren't paying attention, etc. So you always have those, we call them comparative negligence arguments, that the cause of the accident was the plaintiff's own inattention, that type of thing. So in that case, we had that issue. And we also had some medical issues in the case. This case involved a woman who, 8 or 9 months after the traumatic fall, was diagnosed with a herniated disc. Well, because after falling, she got up, was a little sore, continued to work that day, and only went to her primary care doctor a day or two later, and over the next 8 or 9 months, never lost any time from work. There was interesting causation issues because her accident happened, I think it was on like February 1st, and she wasn't diagnosed with a herniated disc until September of that following year. So it was a case in which the defendant hired an expert neurosurgeon out of state, and they said that, well, she may have had a herniated disc 8, 9 months after the accident, but it had nothing to do with the accident. It wasn't causally related. She had some aging, some degeneration of the spine, and it was her aging, degeneration of the spine that was the cause of this serious herniated disc. And so it was a case that was vigorously fought over the issue of medical causation. Fortunately, we had a treating surgeon at the UMass Medical Center that was willing to be an expert witness for the plaintiff. So it had some interesting issues, but it did end up producing a pretty good settlement considering those issues.